Welcome to the Heart of Law podcast. My name is Mirena Umizaj, and I'm your host. My guest today is attorney Jennifer Moore. She is the founder of her own law firm, the Moore Law Group PLLC, based in Kentucky. Jennifer has successfully led numerous class and complex litigation cases in both state and federal courts. Jennifer tried a case in federal court involving Roundup, proving that it caused her client non-Hodgkinson lymphoma, resulting in an $80 million verdict against Monsanto and leading to settlements exceeding $10 billion. In addition to her law practice, Jennifer is the founder and past board chair of Emerge Kentucky, a nonprofit organization focused on training women to run for elected office. To date, Emerge has trained over 250 women, and currently 42 are serving in office. Jennifer also served as a chair of the Kentucky Democratic Party from 2007 to 2009, and she's currently on the boards of Emerge Kentucky, AAJ, KJA, and is a member of the Kentucky Supreme Court's Rules Committee. She is a badass. Jennifer, welcome to the Heart of Law podcast. It's a pleasure to have you on.
Thank you so much for having me and for that very kind introduction.
I mean, it's so impressive. And it's just such a pleasure and a delight for me to have an opportunity to talk to you about your career, because you are the kind of person that seems happy in her career, and that you love what you do, and that all you do is just set the standard higher and higher. So to be able to have an opportunity to hear from you and to share this with our audience is truly a pleasure. So there is a lot I want to cover today. Let me just say, before we jump into, because there's a lot of, in terms of the legal industry, there's a lot to cover. I would love to just start with why you wanted to be a lawyer in the first place, and do you regret the decision?
Well, I'll start with the second question. I absolutely do not regret the decision.
Okay.
I love being a lawyer. I love being an advocate for those who need a voice. And when I was very little, I decided that I wanted to be a lawyer, and I never strayed from that, which I know is somewhat unusual for most people. But when I was in elementary school, I think a couple of different, at the time I didn't recognize it, but reflecting back, there were a couple of different factors going on for me. When I was in elementary school, my aunt was going to law school, and that was very influential for me. And then also at the time when I was in second grade is when the president appointed Senator Day O'Connor to the United States Supreme Court. And I remember very distinctly that she was appointed as the first woman Supreme Court justice. And even as a second grader, I thought, wow, that's really incredible. And I also can remember thinking, wow, that's incredible that she's the first. And then I thought, I'm going to be the first Supreme Court Chief Justice woman, and so that was where my brain went. And I actually wrote a book report on Senator Day O'Connor in third grade. And from then on, I was like, that's what I want to do. I want to be a lawyer, and then I want to be a judge. And not so sure about the judge thing now. I like being the lawyer better. I like being the advocate more. But that's why I decided to do it. And, neither of my parents are lawyers. They were obviously huge supporters of me my entire life and got me on the path where I am now. But I just think you can, as a lawyer, you can truly make societal impact in ways that you don't necessarily get to do in other fields. And that's what I love about what I do.
Yeah, that's awesome. Yeah, and I remember being confused about what I wanted to do in life until I graduated college. So when I hear the stories of like, oh, I knew in second grade, I'm like, clearly you were tuned in. And so it's amazing that to have that clarity, right? And I think to be inspired. So that makes a lot of sense that you had that figure in your life that sent the message, the right message. Obviously, the law industry is broad, but you sort of focused down the path of like personal injury, medical malpractice, mass torts. Can you take me through that journey?
Absolutely. And I think everyone's journey changes along the way.
Yeah.
I didn't graduate law school and hang my shingle. Some people do that and they're very brave. I wasn't that brave to do that. I graduated law school and I had the wonderful opportunity to clerk for the Sixth Circuit. And I clerked the chief judge of the Sixth Circuit, who I absolutely adored. He's no longer with us, but he was a huge influence in my life, Judge Boyce Martin. And so I had that opportunity, which I would encourage anyone in law school to do a judicial clerkship. It is an amazing experience to develop that relationship with a judge, but also to see what it's like behind the scenes. I credit Judge Martin with helping with my legal writing and getting me on that pathway. Because, in the plaintiff's practice, sometimes people don't really focus on those legal brief writing skills. But when you clerk for a federal judge, you better be, very sure that you know what you're doing when it comes to writing. So I did that. And then I did as many law students do, because I think our law schools in this country kind of create a situation where it seems like the only path is to go to big law. And I try to tell law students all the time, that's one of many paths in the law. As you said, the law is very broad. But I did the big law thing. I went from my clerkship, I went to San Francisco, and I practiced at a big firm. At the time, it was Sonnenschein, Nath, and Rosenthal, which has later been bought by Denton's, as many law firms have been bought by Denton's. And I did that for about 3 years. In some ways, 3 years too long. And it just was not for me.
Right.
Doing commercial litigation, representing insurance companies, there is a place for it, but I thought that I could use my skill set a different way and to help people. And so then about 20 years ago, I changed my practice completely and came and started doing plaintiff's work and all personal injury. And that's how I got there. So I think it's important for, law students or even young lawyers to recognize that, like, you haven't signed you haven't signed in blood that you're going to stay on this one path your whole career.
Right.
And I just kind of found my way. And when I started as a plaintiff's attorney, I didn't start just doing mass torts. I didn't start going in and trying, the bellwether trial. But I really started with representing anyone who was injured, whether it was medical negligence. I did a lot of medical negligence work. I did, car wrecks and truck wrecks. I did motorcycle wrecks. I did dog bite cases. I mean, whatever people needed help with, that's what I did. I've done a ton of police pursuit cases, products cases. And because of that, I got myself in the courtroom, especially as a young lawyer. And that kind of morphed into then doing mass torts. Bringing that experience of actually being in the courtroom to the mass tort world.
Yeah. I'm just surprised, I'd say, like, sometimes by how little attorneys like being in the courtroom, right? And because if I had gone to law school, I didn't, but if I had gone to law school, I think I want to be the courtroom attorney. I would want to be like there in the fight. But do you think that's a personality thing, or is it, why do most attorneys shy away from trying all of the cases, taking as much as they can and throwing themselves in that environment? Why do you think that is?
Well, I do think it's personality. But I also think because at my former firm, so I started my own firm in 2007. And at that time, I had a law partner. And he used to always say, because he started practicing in the early 1980s, that like the first week of his practice, he was in a trial. They handed him a file and said, go try this case. That does not happen anymore.
Right.
And so it used to in the 80s and 90s, and even probably a little bit in the early 2000s, people would go to trial all the time. And I think, mediations and arbitrations have really shifted that. So it's not so much that most attorneys don't want to be in the courtroom, just the opportunities to be in the courtroom have really decreased compared to where it was 20 to 30, 40 years ago. And especially when you're talking about, high stakes litigation like a mass tort, where, it could be billions at stake for the defendants, it is a rare opportunity then to get into the courtroom. And then when it is, it's almost impossible for a young lawyer to do that because of the financial stakes, right? And that's why I think I was really blessed with starting as a true PI attorney and being able, I tried a car wreck case. I did it all myself. I didn't have any staff with me. I didn't even have an assistant. I just did it all. Went and lived in the Holiday Inn in Frankfort, Kentucky, and tried the case and won. And I think developing those skills will benefit you for your entire practice. And I think a lot of attorneys, even in the mass tort world, they really want to do that. It's just the opportunity may not be there.
Yeah. Do you think so? I mean, I think you made a good point. The financial, the resources, that aspect has to be there. And so it's expensive to try a case, right? And then if you lose the case and you don't have a robust practice that's, providing cash flow, it's very difficult to sustain that lifestyle. But yeah, I think as I meet more and more lawyers that sort of come from personal injury into the mass tort arena, and they say, well, I don't even know where to begin with mass torts. It's like so political. It's so this, it's so that. How does somebody that is eager, that has trial lawyer skills, that has a desire, to do mass torts the right way, what is the path? Or, are they wasting their time?
I think you're wasting your time. Well, one, I think you should always do something that you love. And if you love doing medical negligence cases, you should do medical negligence cases because you're going to excel. I got to the point where I got a little burned out about it. But I think that's number one. So you got to pick something that you love. And for me, I love representing people who have been going through cancer. And that may sound a little strange, but the impact cancer has on someone's life is just, it's really hard to even describe. Yeah. And I think until it hits you personally in your own family, which unfortunately it did for me, you recognize that people are just kind of lost when that happens to them. And they really need someone who can stay focused on what can we do to hold the company accountable for exposing you to this carcinogen. And so to me, that's why I still love what I do, because I get to help families who are dealing with cancer. So I guess that's one thing I would say is if you want to switch from PI to mass tort, make sure you're doing it for the right reasons.
Yeah.
And then, the reason I ended up trying the Roundup case in 2019 was because I had trial experience. And many people in the mass tort world don't have the trial experience because of that opportunity, that lack of opportunity to get into the courtroom. But also they've spent their career managing large dockets and not getting in and doing depositions and arguing motions. And so I would just say that if you're going from a PI practice to a mass tort practice, you've got the skill set that a lot of people don't have. Right. And make that known and get in there and get a leadership position. And, and sometimes you got to figure out, how to start that mass tort yourself. So
right.
Don't shy away from taking risk, right? That's, if you're a plaintiff's attorney, whether you're a PI attorney or a mass tort lawyer, that's what you do. We're not risk averse people, and don't become one now,
Yeah, no, I compare trial lawyers, good trial lawyers, to entrepreneurs. It's like starting a company, right? All the risk that you take with starting a venture and then getting it to cash flow, which, it's really the same grit. It's the same self-discipline. It's the same, you got to start from the basics and then not be afraid to take it all the way. So you mentioned the trial against Monsanto. Of course, that was a huge highlight for you, for your client. And then it led to the resolution of a lot of Roundup cases. And so you were, central figure in this litigation. What was that experience like? Did you expect that verdict? How did that impact and change you or your trajectory in your career, if any at all?
Well, it absolutely changed the trajectory of my career. There's no question about that. And I think my co-counsel, Amy, would say the same thing. For her, it's interesting because I don't think there was at any point in time prior to trial. So I'll talk about what happened during trial.
Yeah.
But the months leading up to trial, I don't think there was any point in time where I sat here and thought, wow, this could change the world, or this could change on a personal level, my practice or the trajectory of my career. I never thought that. I didn't, probably because all I did, I had my head down working, right? Because we started trial the end of February of 2019. Mm-hmm. And I can remember distinctly Thanksgiving of 2018, reading depositions and doing depo cuts. And I went out to Colorado the first weekend of December of 18 and stayed at Amy Wagstaff's house, my co-counsel. And Amy and I spent the whole weekend doing nothing but getting ready for trial. And from that moment on, all I did was work to get ready for trial. And you just don't sit around and think about well, what will this mean? I mean, our whole purpose then was, how are we going to win? Right. And we got to win. And we knew that winning that case would have a big impact on the litigation. And we knew that obviously winning that case would be wonderful for our clients. But it was not until the first day of trial that I recognized, oh, this is a whole new level. Because, I went in the day, so I did jury selection.
Yeah.
I love jury selection. It's my favorite part of trial. Well, maybe a closing argument. But I love jury selection, and I've done it in every trial I've had, maybe except for the first couple I tried with my former partner. And in federal court, Judge Chabria did a day of just hardships. So we would go in and argue hardships. And the only people that were there that day was myself, our jury consultant, and our local counsel. That was it. There was nobody in the courtroom behind us. Monsanto comes in, they've got 40 people over there. And that was it. And I just, to me, it was just like any other trial I do. Right. And so I went in and made the arguments on hardships and try to, keep some people that probably shouldn't have been kept and all that. And then went about my business, went back home and started studying that jury pool, and then showed up on that first day of trial. We get off the elevator and there's this line. And I thought, are we on the right floor? What is going on? And I turn, we go into the courtroom, and they actually have one of those, a crowd control, like you do at the airport. They had that out, and people are standing in line to get into the courtroom. And I was like, oh, people are paying attention to this case. Okay. All right. But I never thought about it. It's so, now I look back and think, well, what was I doing? I realized, I was working. I didn't have time to think about that. But they even had an overflow courtroom that first week. That was crazy. It was intense. And then,
was that intimidating? Did the nerves kick in at that point, or what happened?
Oh, it just gave me more adrenaline. It was I was like, oh, and I run a pretty tight ship at trial. And of course, Amy and I were the only ones that tried that case. And we had a team of people And I can remember I sat down with the team the night before and I said, no one is allowed to come to counsel table. Everything has to go through my paralegal, who Mary, she's been with me for 14 years and she's awesome. And I couldn't do it without Mary. And so I would say, if you need me, you go to Mary. Mary will decide if that comes to me. And so we ran this very tight ship. And I just, no, you just focus. You focus. The only people that actually matter in the courtroom, it's not all the media in there. It's not, the 30 Monsanto attorneys or the appellate lawyers who are sitting there watching to like figure out what they're going to appeal on. It's not any of that. It's the jury. That's all that matters to me. And so I always sit, closest to the jury. And that's how we had it. We had our counsel table. It was me, our client, and Amy, and then the jury right here. And I just was laser focused on that. And you have to be. You can't get distracted by all that noise. But yeah, I mean, most time you try a case, there is nobody sitting back there watching. Yeah. So, but yeah, and then it would just get a little crazy because you'd break for lunch and then everybody wants to talk to you and you're like, no, I have to go work. Like, unless you want to do something, like, do you want to help? Want to work? Or are you just here to watch? But yeah, it was an amazing experience. And what was probably one of many amazing things about that trial was that nobody thought we were going to win except for myself, Amy, and our client. We were convinced we were going to win. And you got to try a case like that. You can't go in trying a case thinking you're going to lose because the jury will be able to sense it. It reminds me of like, I used to ride horses when I was growing up. And my grandfather, we always had horses. And we'd go to the barn and he'd say, listen, that horse will be able to sense it if you're scared. If you're scared, don't get up on that horse. I'm like, I'm not scared. I can do it. And, I got thrown and bucked and kicked and everything. And every time he'd say, you need to get right back up on that horse. And he said, but don't let them sense your fear because it'll be different. Same thing in front of a jury. You just, you got to get in there to win it and don't let them sense that you're afraid of that.
Yeah.
But when we tried that case, I think because people didn't think we could do it, and then we did, that was, but I've been underestimated my whole career, so it didn't bother me. But it was pretty satisfying at that.
Yeah, it's a huge win. How was it working with Amy, by the way?
So Amy and I had been friends at that point for probably, almost 10 years.
Yeah.
We had never tried a case together. We had never worked together. So we lived together. Mary, my paralegal, lived with us. So we had a townhouse in San Francisco, and the three of us lived together. And it was really kind of our other war room. We had an office close to the courtroom, and then we had our war room in our house, and everybody would come in. I think it had a keypad lock, and I swear to God, everybody knew that keypad code, and they just randomly come in. I'd have to start reminding people like, hey, we live here. I could be changing or something. Like, can you all like knock before you walk into the house? But it was great. It was an amazing experience. I basically lived there I was there multiple times in January for hearings and status conferences. And then I moved there in February and came home in April.
Wow. It was also, how many times have two badass women gotten together and tried a case and gotten an $80 million verdict? So, that it sent a message, and it was truly inspiring because you were able to show what's possible. And I know that a lot of women in this profession look up to you and Amy because I don't think that had been done before, right?
I don't know. I actually don't know the answer to that. Where, we split everything up. So I did jury selection, she did opening, I did closing, and then we divided up, basically the witnesses, both the fact witnesses and the experts. And it made it was great because like she started with the epidemiologist, so then I could be focused on getting ready for the hematopathologist. right, which was going on the next day. So it was nice to like have someone that you could rely on, right, to divide up that work. It made it very manageable, especially when you're in trial that long.
Yeah.
And that
Right.
can be pretty brutal to be in trial that long.
Right.
But it's great. I mean, I'd do it again in a heartbeat. I would love to.
Yeah.
Love
I love that. I love that because I mean it shows that you love what you do. Um, Obviously, you've taken a unique path with mass torts. I'd say 98% of the people in mass torts, they see a project come up, they go acquire cases, they aggregate them, they keep them in house, or they ship them somewhere. Your style has been to, work on the cases that you take on and then litigate them, and not necessarily through the MDL, but in federal court. So tell me about that approach and why. I mean, obviously it's very effective, but why did you take that approach? Or do you usually take that approach?
Uh, when I first got involved in mass tort, so that would have been probably 2008, 2009. It really kind of just all fell together because I do think you have to take an opportunity to put yourself out there.
Yeah.
And everything, you mentioned earlier about how political mass torts are and the mass tort world is. And of course it is. Everything's political, but it's also all about relationships. And so I spent a lot of time, building those relationships and traveling and being on the conference circuit. But my kind of entree into mass torts was because an MDL got formed and it was assigned to a judge in Kentucky. And because I had those relationships with other, in particular women around the country, Elizabeth Cabraser was appointed lead counsel, and she asked me to come in, and I was appointed liaison counsel. So that was kind of one of the first things I did in the mass tort world and what an incredible experience, right? Elizabeth has been a true mentor and a friend to me for well over a decade now, I guess 14 years. And that's how I got to start in my very first MDL appointment was under Elizabeth as liaison counsel. So I learned from the best. And so when I initially started it, I was doing what most people do as, okay, what are the current mass torts? What's everyone working on? And starting getting cases. And in Kentucky, there's not many people who do mass torts. And so I have a lot of friends who are great PI attorneys, but they get calls on mass torts. And so they started sending those to me. And so it just started kind of building from that. And then I started getting into the situation where I'm like, wait a second, I've got all these cases, but I'm not really litigating them, right? We're filling out forms, and I didn't really like that. And I wanted to get more involved. And so I then started going to more conferences and started getting more involved and staying more focused on, okay, this is the path I'm going to take, and being deliberate about which mass tort I want to get involved in, and not falling into that trap of saying, oh, here's the 6 mass torts that are hot right now. I'm going to get cases for all 6 of these. That I think is sometimes a recipe for disaster. So instead I focused, and like right now, I mean, I pretty much almost exclusively work on Zantac, but I do it as running the litigation in California and Delaware state courts. And to me, that's merging the best of both worlds, because I still get to be that lawyer, but I am helping thousands of people.
Yeah, but you also just do away with all the politics that come with the leadership, and this person is appointed, that person is appointed. So I'm just curious to know, like, I'm assuming you don't care for it because you've found the best way to not partake in it. are you deliberate about avoiding being on leadership with all these other firms, or is it just the way that it sort of worked out for you where you find yourself or enjoy yourself working these cases in federal court? I mean, is there a
State court? Yeah.
state court, sorry.
No, that's okay. I don't think it was deliberate. I mean, I've litigated for, years in federal court, and state court. And of course the Roundup trial was in federal court.
Right.
And I mean, it's been the only one in federal court that's been tried. All the other cases have been tried in state court. But I think it's more about what makes the most sense for your clients. And you have to take, I mean, I tease my co-counsel in Zantac, Brent Wisner, because we were on a hearing one time and he said to the judge, we were arguing that the defendants had removed some of our Zantac cases to federal court from California state court. And we were arguing remand, and they should have been remanded, and they were remanded. But he said, Your Honor, it's my job to forum shop. And I thought, oh Lord, did he just say that? But he's right? It is our job to forum shop and figure out what makes the most sense for that particular case for our client, because at the end of the day, we're their advocate. And so we need to figure out what makes sense. But no, I mean, I work with other firms all the time. I couldn't do this without working with other firms. And if anyone thinks they can go in and do a mass tour all by themselves, they are crazy. They've never done one then, because you got to have a team of people. And I wouldn't say I wouldn't want to do an MDL. It's just from when I started doing MDLs, 14, 15 years ago to now, it's so different.
What's different?
I don't think it's effective to have 30 or 40 people on committees. I just don't. Because what happens is it always ends up that a handful of firms are going to do the work, and it creates these weird dynamics when you have so many people. I also think that, the defense gets to choose who represents them, right? And they can say, this is the leadership structure we want. Here are the attorneys we want to be in charge. And the court will say, okay. On the plaintiff's side, it's in a situation where you basically are trying out. And sometimes it doesn't matter, at least in some litigations, it doesn't seem to matter like who has done that work. I feel like we've lost focus on that. And we need to be, and when I say we, I mean the attorneys, the court system need to be focused on who is the right person, who are the right firms to actually lead the litigation, because that is a very monumental task. And if you put people in there that don't have the experience to do it, you are doing a disservice to thousands of plaintiffs, and you are benefiting the defense. And I've seen that happen in the last few years, and it ends up disastrous for the plaintiffs and the people who are really, who really end up getting hurt by that, or the people who were hurt to begin with, right? Yeah. And it's unfortunate. And so I just, that part to me leaves a little bad taste in my mouth, because I think that if you have a team of people working together on a litigation and working up the science, working up the experts, and they say, okay, now we're going to go and try to get this MDL created, because frankly, you have to have a coordinated proceeding, or it won't work, whether that's in federal court or state court. You got to have a coordinated proceeding. But if that group presents that, then I think we need the courts to really listen at these are the people who have been working this up. I think we're getting sideways into like, well, we need to have this kind of structure and that kind of structure. And yeah. I want
much gets down. I mean, look, that's as an outsider, and I'm talking to clients. A lot of the time, my clients are in leadership, and I think it's unfortunate because a lot of them just want to be lawyers and want to work, and then they get caught up in the business of who can claim more hours for common benefit and who's positioned first, and so it takes away from the actual work of representing clients and we're being in front of a judge and a jury. So I think that continues to sort of become a subject when I meet with attorneys and they talk about, just the politics. I just want to be in the courtroom, right? But I think what you've done is incredible, which is carved your own path. And at the end of the day, you're working on a litigation that calls to you, you believe in, you're dedicating your time, your effort, your resources. You're working with some of the best. I mean, Brent is amazing. Amy's amazing. Elizabeth Cabrazian. These are the top people in the business. So it's just really cool to see that. And, I hope that it trickles down to, to the rest of the industry, because I do think that there is a question on where this industry is headed to, right? In terms of the long term, like the next 5 to 10 years. I don't know. You tell me. I have my theories, but I'd love to hear what you think is going to happen to the business of mass torts.
That's interesting. I don't know. I mean, I'd love it to be a situation where it's not needed, but given corporate misconduct at times, I'm going to say it's always going to be needed. And you got to have look, our job is to keep people in check, right? And to hold them accountable when they stray from where they need to be. And that straying from where they need to be harms people. But there's a couple, I think, components of mass torts that we're all going to have to take a really hard look at. One would be the influx of digital advertising. And there are pros and cons to that. One of the biggest pros is that it gets the message out there so quickly and accessible to so many people, right? And that's really important and critical. So like in Zantac, this is a drug that the FDA ordered to be recalled from the market immediately in April of 2020. And the reason they ordered the recall was because it has a known carcinogen in the drug. Right. And so that is, to me, a safety issue. We need to make sure people understand that, right? And so that's a wonderful thing about digital advertising, is because you can touch so many quickly. One of the negatives would be that now the number of cases is just exponentially grown. Now, probably those numbers have always been there, right? But more people now understand, I have the right to seek redress for the harm that's been caused to me. That's a positive. It really is truly a positive. But then, where it makes it more challenging is you have, 100,000, 150,000 people who are harmed, not just 10,000 people that are harmed. Well, let me say this. They were always harmed, but now you have 100 to 150,000 people who are seeking compensation for that harm, whereas 10 years ago, it might have been 10 to 15,000. And that's something that companies are going to have to address and be aware of, but it's something as an industry that we have to figure out how to manage, because with the onslaught of digital advertising, what happens is people don't understand. They're signing up for this law firm. They think that they see another ad, it's the same law firm. Now we've got multiple law firms representing the same person. Nobody knows. It creates a little bit of an issue. That's something on the industry side that we need to really kind of get a good handle on. The other thing I think we need to get a good handle on the industry side is the influx of private equity. And again, I see both sides of that. The benefit of private equity being involved is that this is a very expensive business, because at the end of the day, you mentioned earlier about being an entrepreneur. I am an entrepreneur. I own a small business. I employ 15 people. And that is costly, right? And I worked on Roundup for 5 years before I ever saw a dime. Most people can't work 5 years without seeing a dime. You wouldn't have a very successful business if you didn't have, a profit for 5 years. Now, I had my single event practice, and I had a good business model where I wasn't dependent. I think it's important to diversify. But for private equity, I think the fine line there is it gives people the financial resources to run their business so they can help people. But then you want to make sure that private equity is not running your business.
Sure.
So that's something I think we have to take a hard look at.
Yeah, I agree. No, I am in the business of helping law firms grow. And for now 10 years, we have, made it easy for law firms to access the capital so that they can get more cases and make, have a bigger impact. I completely agree with you on the issues of advertising. I do think that it's a responsibility within the legal business. So if a law firm spends $5 million to go acquire cases, you want to make sure you know where the cases are coming from. What happened with Camp Lejeune, that a lot of law firms were upset, was a big part of their inventory was fraud. That's because nobody was checking to see where their cases were coming from. And you had 3-4 different layers of people all the way to India that were making up cases, selling them for $4,000, $5,000, $6,000 a pop.
Oh my God, that must be I can't, that's just, yeah.
It's a business, right? So I think it's a responsibility that as a law firm, you have to, your name is being used to advertise. You have to know who you're working with. You have to screen those cases as soon as they come in the door. Make sure they're legit. Make sure that you can classify them correctly. You know exactly what you have to work with, and check on dual reps and triple reps and order the medical records. And I think what happens is, because again, we've shifted from a profession to a full-blown business, and you've got people that are more interested in the business than the actual, profession of representing people, is that you're acquiring cases in bulk. You are not doing any work on them for sometimes a year or two. Your retention drops significantly. And then you're not really willing to put any money to work them up because you spend all the money trying to acquire them.
That is a recipe for disaster, what you just described.
Well, that is what's happening out there in real time. Okay.
I mean, I would say number one is, for anything, right? You've got to do your due diligence, because at the end of the day, your reputation is so important for a multitude of reasons. Yeah. Just like, the old saying, like, my word is, my bond is my word, or whatever that saying is. Now I messed it up. But it's so important. Like, you just, and don't just like, oh, let me just invest in, with this company that just started last week to go get me cases. I mean, do your homework. And there are some amazing, very reputable companies that do digital advertising, and have for a long time. But you're right. Like, you got to do your homework, do your due diligence. And then once you get the cases, I had someone say to me the other day, well, if I can get some Zantac cases, like, how much money would I make? I'm like, well, that's not really the right way to look at it. And it gives me a little, I don't really like that very much. But if that's your mindset into going into mass tort, you're going to have some problems, because I've been doing this a long time. I've seen a lot of mass torts. They don't pay anything. Not every one of them is a winner like Roundup was. And there's been a lot of losers too. I mean, it's risky. It's a risky business. It really is a risky business. But if you come into the idea of it and say, okay, I'm going to give this company money to go get me cases, I'm going to get the cases and I'm going to sit on them for 2 or 3 years and wait for other people in leadership to do all the work. I mean, that is kind of infuriating, but I mean, that's their problem. It just hurts the clients. And then it also hurts that business because you're right. Now you turn around, let's say that we get a global settlement, which those are not as common as they used to be. I mean, 3M is a global settlement, but a lot of the settlements now, like Roundup is not a global settlement. That was by firm. So it was by docket, it was not global. But if you're going to sit around and wait for leadership to come and tell you, oh, we've got a global settlement, you might turn around and if you thought you had 1,000 cases, you might have 200.
Yeah.
Because you've not called any of these people. I mean, talk about the rules of professional responsibility. I mean, you have to maintain communication with your clients. So that probably, that's kind of all tied to what I was saying when you were saying, like, what's the future of mass torts? I mean, we have to think about and be smarter about how do we keep our clients informed?
Quality.
And how do we communicate? Yeah.
Quality versus quantity. And look, capital is not leaving. I think capital is here to stay, but it's up to the law firms to also set the boundaries. I mean, sure. I work with a lot of capital groups, and I can tell you the ones I work with are not interested in the litigation aspect. They just want to find the best. Like, they were like, how can we get to Jennifer Moore? We want to give her as much money as possible because we know she's going to do great. They do not want to give money to somebody that is not a trial lawyer, that doesn't have experience, and then tell them how to litigate the case. I mean, it just doesn't work that way. But capital is smart in the sense that it used to be mass torts is where the shiny object was. Mass torts, like you said, is not. It's really, I think, what's evolved for me that I've seen is the very well diversified law firm that has a deep bench of litigators, that has resources at their disposal quickly when the right project comes along. There is cash flow coming in from different cases, different practice areas at any given time. I mean, a true law firm that runs their own ship, and then they dictate their own journey and their own destiny. It's not for the faint of heart. And I think that there's so much misunderstanding about how the business of mass tort works, that billions of dollars have gone to waste, if not more. And a lot of clients have not received the representation they deserve and need. And so I think setting the tone, or at least setting some very simple parameters. It's like, one, just get very good at the litigation if you're going to get involved. Like you said, don't go into 6 and then don't do any of them. Like, right. If you're going to go into one, just know what you're getting into. If you're going to work with co-counsel, make sure everybody knows what their responsibilities are. Like, are you going to communicate with the client? Am I ordering medical records? Like, everybody knows what to do to work up the case and get it ready. And then divvy up the resource, the expenses, or if you need to get a bank line or you need to borrow some money, make sure it works for the budget, and that you're never going to be in a situation where you can't afford to take the case to trial, especially if you represent 10,000 people, right? So, I mean, I kind of
defendants know that.
My thoughts.
Yeah, defendants know that. You're not helping yourself in that situation. I mean, the defendants know, like, who's got debt and who doesn't, and whose firm is, solvent and thriving, and, won't be afraid to put $1 million in to go try a huge case. I mean, they know who that is. Yeah. And you definitely want to be one of those people, right? Because, I mean, look, at the end of the day, what drives the defendants to the table to talk settlement is because they're scared they're going to lose. And so you got to create a situation where they understand that the risks are too high for them to try the case.
Yeah. Are you, what are your thoughts about lawyers and non-lawyers partnering and doing
Trying to
business?
get me in trouble asking me all these questions.
Hey, I want to know.
Well, let me say something. I'm not an anti-private equity person. I just want to be really clear about that. I do think it's something that we have to be mindful of as an industry. Now you've hit another hot topic. Lawyers and non-lawyers. I don't know. We obviously don't have that in Kentucky. And I don't know really what I think about it.
Yeah. Because it's an unknown, right? In so many ways. Yeah.
Right. I do think, and it's kind of a similar thing to me with private equity, is that, I'm not going to go in. I certainly am not going to go into a hedge fund or a private equity group and tell them how to manage their money. I mean, I might have some ideas, but they shouldn't listen to me. And I wouldn't want someone to come in and tell me how to practice law. So I think, there's a little bit of a fine line right there. I mean, it's one thing to say, okay, now let me start a business, and I'm going to start a business, with so-and-so because they bring this to the table and I bring this to the table. But you got to, from an ethical standpoint, you got to stay in your lane. And you can't let non-lawyers get into your lane when it comes to the practice of law. So, but I don't think I have a strong feeling about it.
Well, if the two could stay in their lanes, right? Because, I actually interviewed Linda Shealy, who was sort of the force behind the change in Arizona. And she said, look, I think at the end of the day, it's all about, making sure that the business of law and the profession of law can coexist. So that you can represent and touch as many people as possible. An accountant can be a partner with a lawyer, and the lawyer, and everybody knows that a lawyer needs a CFO, right? And so if you can partner with a really good operator, they can run the business and you can just focus on the litigation.
Sure.
Then why not, right? Now we're talking about capital. I think capital, if they would come in, again, they're going to want to bet on the best litigator, right? Because they're going to open the pocketbook and they're going to say, we have access to as much money as we need, but we're going to run the business. And you just focus on litigating the case and going to court. And as long as those two stay in their lanes and everything is ethical, I don't see an issue. But I also can see where people are people and people, blur the lines all the time. So I think it's going to be a little bit of trial and error until they get it right, or maybe they shut it down entirely. I don't know.
Yeah, I don't know. I mean, we haven't had to face that here. But I'm not opposed to it. I think there are some situations where that would work. And look, at the end of the day, I mean, and I hear this from my friends, my lawyer friends and also my doctor friends. There's a lot of, they're like, oh, I didn't go to medical school or law school to run a business. I'm like, well, then why are you running a business? And I get it. Like they don't have that business mindset, or they just don't want to deal with it. And it's not always fun. But at the end of the day, you have to have that mindset of you are a business owner. It's just my business happens to be a law firm, or if you were a doctor and you had your own private medical group, that's your business. And so I can see situations where maybe it would create opportunities for some lawyers who would be wonderful on their own, but don't want to do it because they don't want to run the business. And that might provide that opportunity. So yeah, I think it's something that should be on the table. And, again, you just have to have, good rules on it.
Do your diligence at the end of the day. Yeah.
That's right. So I'm trying to figure out ways that you can expand opportunities, especially for women, to get involved and to be on their own. And I will say that I've seen that drastically increased over the last decade, especially in the mass tort world. You know, we have a pretty good network of women out there, and there's no reason. I think people are, once you take down like the shield of, oh, owning your own business that sounds so scary. Every person I know who has transitioned into that loves it, has no regrets. The only thing I hear people say is, I wish I had done this sooner.
It's so funny because I had this conversation today. I'm not going to mention her name, but she will probably be listening to this. And it's a badass attorney, actually, and she's in the middle of a transition. And I told her today, I said, if you go on your own, you will never regret the decision. I am yet to meet a person, a man or a woman, doesn't matter, that regrets that decision. Now, it doesn't mean you're going to work less. Doesn't mean you know.
No, you won't work less. Now, let me be really clear. You won't work less. I had someone, I literally, I stole this line from someone the other day who said to me, it was actually a bankruptcy trustee. And he said, I'm trying to go from all-time to full-time work. I was like, oh, that's brilliant. I said, I am going to aspire to that also. Yeah. I would like to go from all-time to full-time work. But no, you're not, definitely not. I mean, and it could be, I grew up, my dad ran a used car lot. And so, I mean, I grew up, I first of all, I drove every kind of car you can imagine, but I also interacted with all kinds of different kinds of people, right? I mean, you didn't know who was going to walk into the car lot, and you didn't know when you went to the car lot who might be sitting over there loafing, while my dad's trying to work, because they just come and hang out at the car lot and stuff. Yeah. But he ran a business, and my mom would do the books at night. Like, he'd come home, and they did all of it like spiral notebooks and stuff. I mean, it was crazy. But she would do the books at night, and that's how we lived. I grew up in that small business mindset where some months it was great and some months it was not great. And like, you could feel the tension, right, in the house, and like things were tight financially because there wasn't that cash flow. Mm-hmm. And so to me, owning my own, this is what I grew up with. And I remember my dad, like, Daddy never got to escape from the business because he ran the business. We'd go on vacation. He'd call the car lot and find out what was going on. How many cars sold today? What are we doing? Are we buying any cars? Same thing with a law firm. But that freedom, say, this is mine. I am in control of my own destiny. I wouldn't trade that for anything.
Yeah, I agree. What is, if there is a price to pay, right? I think there is no ceiling in the legal industry for women. Like, you can go, I mean, you're an example. So you can go as high as you want, but is there a price? Like, obviously you've dedicated your entire career, your life to your business.
Yes.
What would you say, like, if there is a price? Because as women, I think sometimes that's where we get tripped up, right? It's like, well, do I want to have my own business and just work myself to death? Or do I want, to have less hours and have freedom and have a family and have, the things. So like, as a woman, I feel like we just have more barriers to success just purely from a gender perspective, I feel like.
Well, and that's because of the barriers placed on us by society too. That even if you are in a couple, right, that it usually falls to one person, what I would say, the assumed responsibility, right? And so it's easy to fall into that trap. I see it with my friends and my sister too. But I don't think you have to make a choice. I really don't. And I'm not trying to say you have to be superwoman, but men don't make a choice. Why should women make a choice? I mean, men have families and own businesses. What women should too. I mean, to me, it's not so much a gender thing as that, you have to be mindful of how you spend your time. And, I spent probably a decade on the road. And, the travel is hard. I mean, I talk about it with my colleagues a lot, and the travel is really hard. And then that all stopped like that with the pandemic.
Right.
I got off a plane March 1st, 2020 from a conference, and I did not get on another plane for work until August of 2021. And that was amazing. um, but I was going somewhere all the time. And when you do that, when you live that kind of life, I don't care. It doesn't matter your gender, right? But when you live that like kind of life, it's hard to maintain those relationships at your base, right? Because what ends up happening is you see the people on the road more than you see the people at home. And so it is hard to maintain those longer term relationships when you're constantly going in and out.
I relate 100%. I have no friends in town. I mean, I do, but I don't see them. And so my only friends are the ones I meet on the road through business. And so it's a wild thing, but I totally relate to that. I know
make a conscious decision about that too. I will say that the pandemic, it was a wake-up call. And, there's not many positives you can take from the pandemic, but I try to find some positive because maybe that's the way I cope with it. But that part of that was it made us stop in our tracks, right? And slow down our lives and reassess what's important. And I'm so grateful that I was able to spend so much time especially with my dad, the last 2 years of his life. And that was because of the pandemic, because I wasn't on the road. And I just think you have to reassess what's important to you, and what matters. And I think there's a shift. I think there's a shift in the entire world and in society, not just in the legal profession, where here we are doing this interview, right, by Zoom. And before the pandemic, we would have probably flown somewhere. You would have flown here. I would have flown there. That would have been 2 days where I wouldn't be doing other things. And I'm going to roll off this interview. And I actually have a meeting with my special master in Roundup. And so I can just roll right into that and get it done. And then I can, go for a walk with my sister. I mean, so it's transformed us, and we should take advantage of that, and reconnect with those relationships and take some time for ourselves too. I'm not don't follow my example, because I can spill out the advice, but I don't necessarily live that way. But that's my goal, at least.
Yeah. And we all aspire to more quality time with family and ourselves and nurture. I mean, what's the point of working so hard if we're not taking care of ourselves? So really quick, can you give me an update on Zantac for those who have cases and what's going on? There's been all kinds of news. It's November 30th. What's the latest on Zantac? What a roller coaster.
It is a roller coaster. And so, unfortunately, if you're one of those people who had cases in the MDL, I was not involved in the MDL. I want to say that, number one. So, but those cases obviously got dismissed, and they're on appeal at the 11th Circuit. I don't think briefing has started yet on that. But that's truly unfortunate that happened. I still scratch my head how a recalled drug that the defendants admit has a known carcinogen in it, that the experts were unreliable in their opinions that it could cause cancer. I can't get that through me. That's not junk science. That is absolutely not junk science. And that's really the only role of the court as a gatekeeper, is to try to make sure that junk science doesn't get presented to the jury. And we've gone way far from that. And Zantac is a prime example of it. So that's the MDL. Now, the positive stuff that's going on in Zantac is that, so Brent Wisner and I are co-lead of the JCCP in California State Court. And we're pretty far along there. We were supposed to have a trial this summer. It was going to be our first trial. on bladder cancer. It was a plaintiff bellwether pick. We picked 10 picks. They picked 10. And so we had a 20 bellwether pool. We got through in California at Sargon, not Daubert, but we got through Sargon on bladder cancer, which was a huge victory for us earlier this year. And so we were going to trial. We were off to the races. And then the defendants started dropping like flies and settling. And so in June of this year, with the July start date, we settled our big trial. And that was bladder cancer. And then the next cancer up was breast cancer. And we were supposed to start trial November 13th, a couple weeks ago. Mm-hmm. And same thing happened. Defendants started settling. We then settled 4 of the bellwethers that are all breast cancer. Those are all settled now. So we did not do a breast cancer Sargon. It was starting to be briefed, and then they said, we're going to pay you. Now we're going into the new year. We have 16 trials next year in California State Court. So, yes, the first one's in February. That's bladder cancer, also in Alameda County. So in Oakland, which is where Brent got the $2 billion verdict. So we're in the exact same courtroom where he got the $2 billion verdict. And we're going to try that bladder cancer case. And that case will just be against GSK. The other defendants had settled. So, and then we go March, April, June, August. It's going to be a crazy year. So, so that's what's happening in California. There's about 4,200 cases there. And if you have one of those cases, you need to be doing a short form complaint and a plaintiff profile form. None of this fact sheet stuff. That's just a bunch of busy work that nobody ever looks at. So I try to shorten it down. And so that's happening in California. In Delaware, there are about 72,000 plaintiffs. Wow. And we have a 300 randomly selected bellwether pool that are doing plaintiff profile forms. Again, shortened version. That's my big thing. And of what the defendants really need. Like, what are the data points that they will need when we get to settlement talks? And that's what I think needs to be in the profile forms. And so we're doing that with the bellwether pool. We then are doing general causation, Daubert, in January. So we have a 4-day set aside toward the end of January. We disclosed our experts this summer, all different than what the MDL had, except for our testing expert, Emory Pharma. And then they've disclosed their experts. All the experts have been deposed at this point, as far as the ones we're planning to depose. Everyone's deposed, and we're in briefing mode now. So that's what's happening. So January will be a big month. Yeah. We get ready for trial in California and then doing a Daubert hearing in Delaware. And we'll see. I mean, the defense, they want to put all their eggs in one basket, and that's to try to beat us in Daubert in Delaware to try to get rid of 72,000 plaintiffs. We are going to do everything we can to make sure that doesn't happen. And we get through that in Delaware, then this litigation is much, much different.
Wow. Do you think this January trial is going to happen, or do you think they're going to try and settle it?
I don't know.
Especially because it's at the famous courthouse where a $2 billion verdict was won. So that's interesting. So you have a big year coming up. So I'm probably not going to see you at all. But if you do go to a conference or two, I would love to get some time. It's always just such a pleasure. You are inspiring. You are amazing at what you do. Thank you.
Well, thank you. I appreciate the opportunity. And I just, people should get involved in mass torts. We need great lawyers to step up. And, there are so many great lawyers in mass torts. But, we're facing an army every day on the defense side. So we always need more help on the plan.
Set aside all of the things that stand in the way of success and come together and work together well. But I agree. I think that's the right message. And, and very, very quickly, what are you doing for Christmas? Like, we're almost Christmas time. Do you take time off? Like, are you?
I am going to try. So I have a lot of work to do for the next 2 weeks, getting stuff ready because we have all our Daubert oppositions due December 22nd. Yeah. And my goal is to get those done before December 22nd. So we'll see how we can operate with a fake deadline. But I have kind of a big birthday this month. And so I have a bunch of friends coming in a couple of weeks to celebrate my birthday. And then I'm going to the Bahamas. So yes.
I think that's well deserved. And I hope that everything else just kind of goes to the side until you can take a moment to yourself and enjoy and celebrate your birthday and the holidays. Thank you again so much for being you and for being yourself and so authentic and so inspiring. Appreciate your time.
Thank you so much for having me.
Stay tuned for upcoming episodes available on popular platforms such as iTunes, Spotify, and YouTube.